All right, well, welcome back to our Virginia at Work podcast and Corecast, as I always like to say, with Cortex Leadership Consulting. With us for this particular podcast is Lynda McNutt Foster, as well, the CEO of Cortex Leadership, and then also with us, Tommy Strelka. He does employment law here in town. Thank you, Tommy.
Nice to be here.
Let's get right to it because we could talk about this for hours, but we promise you all we won't. Drag it on. White collar law, is that kind of the word we're using for this?
Yeah, I'd say white collar, maybe white collar overtime law.
Talk about what that is. People are hearing about it, and I think they're starting to get a little panicked.
Sure. And let me just say, it's not unusual for people to get panicked about overtime. It's kind of like a daily occurrence in business from my perspective. Overtime is governed by the Fair Labor Standards Act. It's a federal law, went into effect in 1938. Changed the face of American workforce. It gave us the 40-hour work week, minimum wage, overtime, banned child labor. However, as we extend into the 21st century, the issue regarding overtime has just become so incredibly complex. This law has been legislated and legislated. It has regulations on regulations on regulations. Of all the laws that I practice and use in the course of my business, this one is by far the most complex, and it is by far the easiest pitfall for an employer to fall into because it doesn't matter how many employees you have. It doesn't matter how much you're earning, how much the business makes. It doesn't matter where you are. This is a federal law, and it applies to everybody. And I'll leave it at that.
I was going to say, let me leave it at that because you've just made everyone perk their ears up. Just enough, Lynda, for you to tell me when a lot of the people that you are executive coach for, big companies, small companies, they hear what Tommy just said, and they're all getting a little nervous. I think their heart rates are starting to go up a little bit. What are you hearing from your clients?
Yeah, I think this is something that's going to change the way communication flows in businesses. I think this is going to be the way this is going to fundamentally change some things that some people didn't think were broken at all. Right. So you take the millennial sort of workforce in that 18 to 34 who loves that freedom, right? And as a business owner, I love the freedom that I can give them to be able to do that. This law is going to change that some. We love to get emails all times, night and day, and that's not so good anymore. So what it has been up to this moment in time and what brought me to invite Tommy on the show was to talk about this in depth because I think there's a lot of misunderstanding about what's going to happen. They say it's December 1st, but hey, if your payroll started November 1st for December 1st, then it starts on November 1st. And there's a lot of my clients that thought if they were small businesses, you have to have 50 employees. No. So there's more misconception than anything else, and I really wanted to clarify some of that, and then double click and kind of discuss some of the things and specifics.
And is there a simple bullet point of this is who it will affect, or like, hey, if you make $40,000 or less, it affects you, or
So the change that went into effect regards what are known as the white collar exemptions. So the FLSA, the overtime, every employee is presumed to be owed overtime. That is an increase in pay for any hours that they work over 40 hours a week in a typical work week. But the FLSA has what are called exemptions. And so if your job falls into the category of an exemption, then you are not owed overtime. But the tests and the steps that you have to go through to get to understand whether or not an exemption applies. For instance, the FLSA specifically states that job titles are irrelevant. No one cares what the job titles change all the time anyway. So it's what you're doing and what you're doing day to day. And Lynda, what you're talking about regarding this emails after work, so I do a lot of these cases, and the most common area where liability springs its ugly head is workers doing work at home, answering emails, maybe doing some paperwork, catching up on some administrative stuff. The white collar exemption was the exemption that was modified or changed in this instance, and it the white collar is actually a kind of a cover term for three separate exemptions: the executive exemption, the administrative exemption, and the professional exemption. But by far and away, the greatest pool of employees is that administrative exemption, which regards your typical office worker, clerks. There's literally hundreds and hundreds of types of positions that this covers, and it's that area that is the most affected and has probably got the most employers concerned.
I'm going to leave it at that because we could go for another 2 hours on this. I'm going to wrap this particular one up because what we want to do when we come back is talk a little bit more details. You both have mentioned emails. I can't tell you how many people, I included, check emails at home. First thing you do when you wake up and you grab your smartphone, you check your emails. I want to talk more about how that's going to affect an employer and the employee. And if I'm going to get overtime, I'm going to click on my emails as soon as I wake up. No, I'm just kidding. All right, we'll wrap this up. We'll be right back.